Welcome back. Let's continue with some local discussions. Now, we're in the 7th month since the Supreme Court ruled that the General Legal Council should introduce a new system for the 2018 admissions into the Ghana School of Law. Now, the GLC was given 6 months, which elapsed last month. I have here in the studio the Conference of Law Students President of Ghana. You're welcome.
Thank you for having me.
Okay, so two of them here in the person of Noah Ephraim Tete. He's the president of the Law Students Union KNUST, that's him. And also Ni Adokwe Kujo, he's with the Wisconsin Law Faculty. You're welcome once again, gentlemen. So you put out a press conference today, and the heading of that press conference is that the judgment of the court must apply. And you speak on and on and on about how the time has elapsed and everything. But have you really been in touch with the Ghana Legal Council to find out what they're doing about this?
Okay, thank you very much. As last year, sometime around November, there was a conference in KNUST for the deans of the various law faculties, in which we had members of the General Legal Council present.
Okay.
There was a dialogue on the way forward as to reforms of legal education. So we're expecting that there will be a broad discussion between the various stakeholders of legal education in the country. But nothing like that happened. And somewhere in September, we heard of a draft of an airline which was submitted to Parliament. And as you rightly said, from the decision of the courts in Professor Asari versus the Attorney General and the General Legal Council, the General Legal Council was given 6 months within which to put forth a new system to regulate intake of students to the professional level. The time has elapsed.
Okay.
There has not been any broad discussion between the stakeholders. So what is the position of the law now? Per the decision of the court, entrance exams and interview is unconstitutional unless there is a law in place to regulate that. So as it stands now, there is no criteria to assess students before they enter the professional level, except having an LLB degree. But
then we know what happened right after this order was given by the Supreme Court, that there was a system that a system that was already working, and they agreed that the system continues to work.
A careful look at the decision of the Supreme Court, they stated that the regime then was unconstitutional. However, in the interest of the public, because preparation had already been made for the exams to go on last year, that's why they allowed that to go on. And they stated that a new regime must be in place for the admission to the professional course this year. Okay.
Let me ask you, Ni Adokwe, when next do you write exams, or when, assuming the old system was prevailing, when would have been the time that you write exams today, this year?
Okay, good afternoon. So students would be expected to write entrance exams in July 2018.
Okay, so between now and July, you're not just hoping, you are indicating in your press release that you will not, let me just read the conclusion. It says, we want to inform the public that we are aware of our rights and will not be passive to watch loosely while it is infringed upon. Whilst you're not watching loosely, what will you be doing?
Okay, so to tackle your first question, it is not that students are afraid to write the exams, but there are so many uncertainties around the examination. When you have an LLB holder from a university in this country that sits for an examination where the subjects are 9, and you are expected to write all of that in one day, 9 subjects with several subtopics in one day, and then out of that, just about 500 sometimes are told to have out of nearly 2,000. There is reason to be concerned about that. Now, the reason why the Supreme Court gave this judgment was because administrative bodies must exercise discretion, and the discretion must be based on law. It must be fair, it must be reasonable. So, if the General Legal Council is expected to comply with the law imposed upon them, that is Act 32. Now, when you go to Section 13 of Act 32, the provisions there says, Section 13(1)(c), it says, establishing courses of instruction for students, and generally for affording opportunities for students to read and to obtain practical experience in the law. So, in the mind of those that frame this law, opportunities must be given to students to read and have experience of the law. Unfortunately, the entrance exams has either become a tool for preventing students from having the opportunity to read and have experience of the law. And so it is important that when law faculties in this country has increased, then the facilities must also increase. The entrance exams and interview was introduced just because the Mokola campus could not accommodate all these people. And so instead of using the law to prevent students from having the opportunity, rather think that it's time to dialogue and let's see how we can expand the facilities, allow the faculties to run the courses, and the General Legal Council through an independent examination body can take care of examining these students.
Okay. You also say that we beseech Parliament to therefore ensure the General Legal Council implement a system that affords all qualified LLB holders the opportunity to undertake the professional course to become lawyers. What is it exactly you're asking Parliament to do?
As noted, Parliament is supposed to deliberate on laws or bills that are presented to it. We know the General Legal Council has submitted an LI which has been laid before Parliament. What we are asking our parliamentarians is that it is very, very difficult for a student to go through 4 years of legal training, paying huge sums of money and school fees. And then at the end, that fellow will be denied the opportunity of being trained professionally in the country.
But you still get the opportunity to write again, don't you?
You still get the opportunity to write again. And that examination is an exams where you do not know the pass mark. You do not know the marks of those who passed.
Okay.
And it's very difficult for you to ascertain what goes on before a student is even admitted. All you just see is a list comes out and these are the number of students that have passed. So we are asking Parliament that these are rights of people enshrined in the Constitution, our right to education. We are asking Parliament to speak on our behalf, to set aside this LI, to ensure that there is a regime where everyone will have access to professional training in this country. Then at the end, the GLC can put in an examination, which a fellow will be asked to pass before he can be called to the bar as a lawyer, as is done in many jurisdictions. So the right to education should be there. However, to qualify as a lawyer, then there should be an examination that you pass.
Okay. Okay, well, I hope Parliament will hear you out. But before I let you go, let me find out from you what's going to be your next line of action. You'll have about 6 months to maybe write the exam. I mean, if what happened last year is anything to go by, and if as of June there has not been any new interventions by the General Legal Council,
okay,
what will be your next line of action from here?
As I stated earlier on, per the decision of the Supreme Court, legally there is no requirement of examination and interview.
Now I'm speaking on the assumption that you are expected to write the exam again. What will be your next line of action? Will you defy? Will you consider legal action? What will be your next line of action?
Well, the truth of the matter is that we have full confidence in our parliamentarians that they will listen to their constituents, that they would not give effect to a law which can be challenged. I'll give you an example of when the Media Commission came up with the media content standards, and then after it was passed, it went to the Supreme Court and majority of the provisions were declared unconstitutional. We are asking Parliament that it is important we don't repeat certain, for want of a better expression, mistakes. So let us engage.
Okay.
We want Parliament to, not to pass, they should annul this LI. Let's engage. What we are talking about, South Africa had a similar problem, but they have gone ahead in 2014 to come up with their Legal Practice Act 28. Okay. And this deals with all these things. So we can easily deal with this problem without having to use examination to prevent students from having access to legal education. That's what we are advocating.
So you trust that Parliament will listen to you? And if they don't?
Well, when we get to the river, we'll cross it.
Yes, that's a very political answer to give. But if you would depoliticize your answer, it will help.
We have confidence in our parliamentarians. They have been engaging us. They have been talking. So we believe that as they are coming back, some members in Parliament would again listen to us, and then they will do. A number of them are equally against the provisions in the LI. So we are very confident that they would give their constituent a listening ear.
Hopefully so. You have any final words?
Final words is to every student of law in this country, all that we can say is that the time has come for reforms in legal education. In 1976, we heard of Mr. Robin Lukman's article on markets for legal services in Ghana, where he said that the ratio of lawyers to the populace in Ghana is 1 to 15,000. This is serious, and that was 1976. We are in 2018.
So we need more lawyers.
We need more lawyers.
Okay. So the General Legal Council should make it possible for Ghana to get more lawyers, basically, his point. Thank you very much, gentlemen, for coming. Noah Ephraim Tete is the president of the Law Students Union of KNUST, and Ni Adokwe Kujo is from the Wisconsin Law Faculty. Gentlemen, thank you for coming once again.